Friends, today we are going to discuss the topic of curative petition. In fact, it is an innovative tool. Normally, before this curative innovation of this curative petition, there are several attempts to reopen the final verdicts of Supreme Court. We know that the Supreme Court is final court, that is apex court, and review under Article 137 is the final course of action in Supreme Court. But there are several attempts for reopening of the final verdict of Supreme Court under Article 32 on the ground of violation of fundamental rights. So, through this curative petition procedure, Supreme Court laid to rest all such attempts of reopening of the final verdicts of Supreme Court. So, what is the purpose and object of this curative petition? Is that to be corrected orders passed by Supreme Court to be corrected. As we know that Supreme Court is final court but not infallible. It is an apex court. So some mistakes may be correct. So to correct such orders by using inherent power, by using this inherent power, Supreme Court wanted to correct its any earlier mistakes even after dismissal of review petition. So, in the interest of justice, to prevent abuse of the process of the court and to prevent miscarriage of gross injustice, in a judgment, Supreme Court innovated this curative petition. So, come to when this curative petition can be invoked. So, first, provisions. Under what provisions this can be invoked? That is Article 142. So we can add Article 137, 142 and Article 145, Clause 1, Clause T. So, by using all these provisions and articles, the inherent powers of the Supreme Court, the curative jurisdiction can be invoked. What are the grounds when Supreme Court can exercise these powers? Means you come to the Ropa Ashok Purra versus Ashok Purra and others judgment reported in 2002. So in this judgment, a lot of discussion has been taken place whether after dismissing of review petition, after arriving finality of a judgment of Supreme Court, can it be reopened? Regarding this, after a prolonged discussion, Supreme Court came to conclusion that to prevent abuse of its process, so to prevent abuse of the process and cure miscarriage of a gross miscarriage of justice. So one is to prevent abuse of its process and to cure a gross miscarriage of justice, and third, and on these two grounds may reconsider its judgment in exercise of its inherent power. That is Article 142 and all other provisions where it has been incorporated. So this is the purpose of purpose and grounds. Purpose and grounds. Grounds means objects. Come to the grounds. On which grounds the petition can be filed? We have to understand that after arriving a finality of a judgment in Supreme Court, that is in apex court, again reopening of the matter is very hurtful to the litigants, because it is a continuation of litigation from the lower court and it reached up to Supreme Court. Even in Supreme Court also it has become final. Even then review is there. Even after that, again reopening the matter is very complicated and continuation of litigation. So that exercising of curative petition, exercising of inherent powers, exercising of this power and inherent powers of Supreme Court through curative petition, the rarity, R-A-R-I, rarity. That means, very exceptional circumstances only these can be exercised. Otherwise, many number of petitions may come. So what are those grounds? That compelling grounds that aids to exercise these powers are that according to Ropa Ashok Purra judgment, When Supreme Court feels that the petitioner is entitled to relief ex debitio justitiate. What is that? Ex debitio justitiate. Justitiate. Ex debito justitiate means as matter of right. That means the remedy which court cannot refuse, which has no discretion to refuse it. That means ex debitio justitiate means is a matter of right. That means court has no discretion to refuse the remedy, not the relief. That means this doesn't mean every curative petition should be allowed. That means petition can be entertained as a matter of right. When petitioner is entitled that as a matter of right, then what are the grounds? Violation of principles of natural justice. What is that? Violation of principles of natural justice. Particularly in what? In the petition. In which petition? In against which petition? Curative petition has been filed. That in that principles of natural justice may be violated. And the reason, because of he was not party to the list. Suppose one litigation is there between A and B. C is not a party to this litigation, but he was affected badly. He was affected badly. So, because of he was not a party, but he was affected, that is violation of principles of natural justice on that ground. But the judgment adversely affected his interest, then he can file curative petition. This is one ground. Next, another ground is that not that he was not a party, he was a party. Another ground is that he was a party to the list. Though he was a party to the list, he was not served with notice of the proceedings. He was not served with the notice of the proceedings. That means no notice is issued to him. But the matter proceeded as if he had notice. Two things. One, notice, no notice to him. The second one is the matter proceeded as if he had notice. As if he had notice. So, in such a situation, on that ground, this petition can be filed. So, these are the first ground on violation of principles of natural justice. The second ground related to bias. Bias means proceedings are there conducted by one learned judge. He is having some interest or connection, not interest, connection. He is having some connection with the subject matter or the parties. So, a matter which has been heard by a learned judge, who is having connection with the subject matter or the parties, but he did not disclose. That means he failed to disclose. He failed to disclose his connection with the subject matter are the parties. Thereby what happened? Thereby, and the judgment adversely affects the petitioner. Why? Because of his connection with the subject and the R parties. What happened? There is a scope for an apprehension of bias. There is a scope for an apprehension of bias. So, because of non-disclosure of his connection with subject matter of the parties, if its non-disclosure giving a scope for an apprehension of bias, so not only apprehension of bias, and the judgment adversely affects the petitioner. When these 2 points clubbed, because it is undone, when these points club, on that ground also curative petition can be filed. So, this is the grounds. These are the grounds on which a curative petition can be filed. Then, what is the procedural aspects? What court says? When a very strong reason exists, then only this petition has to be heard. In all other circumstances, the court should not entertain an application seeking reconsideration of an order when it has become final, or dismissal of a review petition. So, rarity. Only in rarest cases, exceptional cases, it can be heard. Then come to procedural aspect. The petitioner has to say. So, first, a review petition has to be filed. Suppose SLP for SLP filed, dismissed. Then review filed, dismissed. Then curative. Okay. All the grounds which have been raised in curative should mention in review petition. That is one procedural condition. All the grounds mentioned in the curative petition had been taken in the review petition. What does that mean? No new grounds. No new grounds in curative petition. That is one condition. The second condition is it was dismissed by circulation. So what does the meaning of circulation? Not in open court. Not in open court. That means any review petition filed, normally these petitions will be heard in the chambers. The chambers of the honorable judges. So, there is a chance of hearing these review petitions in open court. When court feels it should be heard in open court on the petition filed by the petitioner for hearing in open court. So, the procedural conditions are that one is all the grounds mentioned in the curative petition shall have been taken in the review petition. To that extent, in curative petition shall never, that we shall state, specifically state all these petitions I have taken in a review, it was dismissed in circulation. So, what is the underlying principle in imposing this condition is that he has filed review petition, he has taken on the grounds, all the grounds, but no court hearing in open court, so that maybe the judges have missed the contentions of the petitioner. Maybe they could not get the total essence of the grounds because of there is no hearing. Because it was dismissed by circulation, there is no chance to take the assistance of the lawyer, of the petitioner who filed that review petition. Only by reading that petitions and grounds on the paper, they came to a decision. So that what happened? Some miscarriage of justice may be happened. In view of that, the Supreme Court put a condition: the curative petition or petitioner should ever specifically that the grounds had been taken and it has been dismissed by circulation. Suppose it is not dismissed in circulation, it was not dismissed in circulation. That means what? Review petition heard in open court. Then, when review petition heard in open court, then curative petition is maintainable? That is the question now, which is pending before the Supreme Court in Brahmaputra, some project industry case. One case is there, Brahmaputra, I think project industries are like that. In that case, it is pending. What is pending? Even the review petition was dismissed by hearing in open court, not by the circulation. Then review petition is maintainable or not. Supreme Court registry is not accepting as of now the curative petitions if the review petition was dismissed by hearing in open court. That has to be decided by the Supreme Court. It is now reserved for judgment. It is reserved for judgment. So this is one aspect. The other procedural condition is that a senior advocate should give a certification. Senior advocate should give a certification. That means what? Senior advocate now has to give a certificate stating that fulfillment of the above grounds. What the grounds have been mentioned in the Rupa Ashok Orra case. That means is 1 and 2. Violation of principles of natural justice or bias or something are there. And all principles mentioned in Rupa Ashok Harra has been fulfilled. So curative petition can be heard. To that extent, a senior advocate has to give a certificate. So this is another procedural condition. Not only that, if we come to the rules, of Supreme Court rules 2013, Order 48. Order 48. 1, 2, 3, 4. 4 rules are there. These rules specifying some procedure. Okay. So apart from certificate of senior advocate, advocate on record has to give a certificate. A curative petition shall be accompanied by an advocate on record to state what? It is the first curative petition in the impugned matter. That means no other curative petition have been filed. It is only one first curative petition. So, one senior certificate and certificate from senior advocate stating that requirements in the pro bono case have been fulfilled. Okay, next. The ground should be mentioned and it should be circulated, right? Dismissed by circulation. So all these are the grounds. Next, come to limitation. What is the limitation to file curative petition? Is that there is no specific limitation in any statute. But Supreme Court Rules 48 says that within reasonable time from the date of judgment or part in the review petition. Within reasonable time. So what is the limitation means reasonable time? What is reasonable time? It may be decided by the Supreme Court. Then what is the hearing procedure? The hearing procedure is that first circulated to a bench of 3 senior most judges. That means top 1, 2, 3 judges. And the judges who passed the judgment complained of, if available. So, if judgment who passed the judgment complained of are available, they also will be circulated. They also will hear. Apart from first a 3 senior most judges bench. So other than the previous judges, the top 3 judges will hear the curative petition. Normally these curative petitions will be heard by circulation. That means disposed of by circulation. That means no without any oral arguments. No oral arguments will be there. But petitioner may supplement his petition by additional written arguments. So there is a liberty to the petitioner to supplement his petition by additional written arguments. Suppose the bench concludes by majority that the matter needs hearing, then it shall be listed before the same bench as far as possible. Suppose a majority judges felt that it shall be listed before needs hearing, then it come to same bench as far as possible. Suppose if the curative petition is without any merit and vexatious, it may impose exemplary cost on the petitioner. So because it is very in exceptional cases, to prevent abuse of the process and to cure a gross miscarriage of justice, reopening of the judgment which have been arrived at finality is an exceptional case. In an ordinary course, if any petition is filed in routine manner, then cost may be imposed apart from saying that the certificate which has been given by senior advocate stating that this petition fulfilled the grounds in Ropa Ashok Khurra case, the Supreme Court, while dismissing this curative petition, can observe that this certificate is, this case is not fulfilling the grounds mentioned in Ropa Ashok Khurra, and the certificate is not correct, and it is not, these grounds are not as stated in certificate. So, these are the principles regarding curative petition. So, this is the essence of the curative petition.